NCAA athletes can now be paid for their name, image, and likeness. When you hear NIL, that's what people are talking about. They can earn money for things like social media posts, personal appearances, autograph signings, and endorsements. It's something that some former players say is a good move for the next generation of college athletes. Danielle Day and Dana Howard join us tonight. They're both attorneys with Stoll, Keenan, and Ogden. Danielle won a national individual swimming championship while at UK. Congratulations.
Thank you.
Dana works in intellectual property and sports law. Dana, glad to have you with us as well.
Oh, glad to be here.
To both of you, and I'll start with Danielle, and then Dana, I want you to kind of pick up on it. What are your thoughts in general about the Supreme Court ruling and the NCAA response on this?
I think it's a big change, but it's a necessary change that came, not at all and then all at once. It's been on a lot of people's minds for years and years now, but I think the combination of a lot of states passing laws to permit students' use of their name, image, and likeness rights, as well as the Supreme Court decision, all kind of accumulated in this perfect storm that forced the NCAA to move and to allow the student athletes to utilize their name, image, and likeness rights.
So, and real quick, Danielle, so this is something athletes have been talking about for some time. It just didn't start to be picked up on a week or two ago.
Not quite. I think depending on what school you attend and what sport you play, you probably talked about it at different amounts. As an athlete, you're focused on what you're doing. You're there to go to school and to perform well at your sport. But there's definitely been an undertone, an underlying discussion, whether that's within the athletic community or even in the more legal economic community that surrounds college sports, in that there's no reason for student athletes to not be able to benefit from their name, image, and likeness from third parties, just like any other student would be able to.
Dana?
Oh, yes, I definitely agree. We've seen lawsuits now for several years regarding these issues. Ed O'Bannon may have been the first. In 2009, he filed a lawsuit based on name, image, likeness issues, and particularly in video games. There were other cases like his. In the Seventh Circuit, there was a Hart case that came about football player with a name, image, likeness case with video games. And then we've seen other athletes sue to try to organize a labor union and be considered employees. What's ironic about the Alston decision is that the Ninth Circuit that the NCAA appealed, the Ninth Circuit only ruled that some of their education benefit related requirements were unlawful, and really changing those would not have amounted to the huge difference and the huge impact that we're about to see now. But the NCAA appealed it to the Supreme Court, presumably hoping to get an exemption for all of their compensation rules, and the Supreme Court did just the opposite. While just affirming the Ninth Circuit's ruling on the educational benefits, we all know that Justice Kavanaugh went a little further and just foretold what the justices were thinking and what was on their mind, and really has put it all up in the air. That combined with the 19 or 20 or so states that have passed state laws that would directly conflict with the NCAA's rules if they hadn't changed them, really put the pressure on.
Danielle, how might have this benefited you, as a matter of fact?
I was a swimmer, so I wasn't in a big revenue sport, but I definitely would have been able to benefit as far as hosting camps with my name on them, being involved in the more entrepreneurial side of that versus just, participating and being paid the normal going rate for a worker at camp. And then I would have been able to do meet and greets and receive some compensation for autographs and even just teaching swim lessons and those kinds of things. I probably wouldn't have been on the multi-million-dollar apparel deals or anything like that, but it would have been helpful for the monetary reasons, as well as just easing my way into the real world and getting some business experience. And I think there are many other non-revenue sport athletes who will benefit from just the overall experience of navigating these waters and hopefully being advised by people who are there to help them and not take advantage of them.
Dana, we have about a minute left. How much control do you think universities will be able to exert on athletes given the situation right now?
Well, I think the schools are going to have to be somewhat careful. They have Title IX requirements still. Most of the state laws and executive orders make clear that they're not trying to remove any of the Title IX requirements. And so whatever universities do with some of their athletes, they're going to have to do with all of their athletes. They need to exercise some limitations on their control, or else they'll be could possibly be considered that they're going into the NIL business with the students, and then that's not really permitted at this time. But they have a lot of leeway. They get to approve contracts. They get in most states, they get 7 days notice to review those contracts, and they control their trademarks. They control their trademarks and their logos, and that gives them a lot of control. So if students are wanting to benefit from their name, image, and likeness and their connection to the universities will have some control over how they do that.
Well, much more to come on this. We could spend a lot more time on it, but at least we got our foot in the door. But thank both of you, Danielle Day and Dana Howard, both attorneys at Stoll, Keenan, and Ogden. And Danielle, again, congratulations on that championship while you're at UK.
Thank you.
Thank you, ladies.
Thank you.